The next matter to come before the court this morning is Ashley Phillips versus Regina Health Center et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, let me know when you get started. I'm keeping the clock. You can also see that it's on the wall over there. Please don't use the names of any minors or victims. This is being recorded. We've posted on the court's YouTube channel. The judges have read your briefs. We're ready to proceed when you are.
Thank you very much. My name is Mark Owens with Brother Associates. I represent the appellant, Ashley Phillips. It's a pleasure to be back with you in person. My first in-person argument, I think, in 2 or 3 years. So it's wonderful to be here.
Would you like to reserve any time?
3 minutes, please.
Certainly.
Thank you. This appeal requires a determination of whether an Ohio employer that's subject to Ohio's mini-COBRA statute does not have to provide notice of continuation of benefits to an employee who is constructively discharged merely because the employer did not have to directly tell that employee that they were terminated. We believe that this court should find that they do in fact have to provide such notice because a constructive discharge is still a discharge. It's not voluntary. Ohio law mandates that the employer shall notify the employee of continuation of benefits when they are subject to the mini-COBRA statute, which Regina Healthcare certainly was. They qualified as a church plan for federal ERISA, which means that put them into the Ohio mini-COBRA statute instead of the federal COBRA statute. If you look at the eligibility requirements for the mini-COBRA, you have to be continuously employed for at least 3 months prior, and Ms. Phillips certainly was. You cannot be voluntarily terminated. If she was not voluntarily terminated, she was constructively discharged. And you cannot have been terminated for gross misconduct, and there's no argument that she was terminated for gross misconduct. So therefore, there'd be no legitimate policy reason to treat a constructively discharged employee any differently with respect to providing notice to them of continuation benefits versus an employee who is discharged for cause for not doing their job. And again, an employee's resignation is treated as if the employer actually fired her. So when you have an employee like Ms. Phillips, due to harassment and abusive conditions in the workplace, feels that she has no choice but to leave her employment, that is not voluntary. It is treated under the law as the same as if an employer had expressly terminated the employee. I would also point out that if appellees really believe in their argument relative to the applicability of the mini-COBRA statute, it begs the question as to why they purportedly sent her a notice of continuation of benefits over a week after her discharge, on January 24th, 2018. Now, I say purportedly mailed because the testimony in the record is that she never got anything ever from the benefits office of the diocese, either before, during, or after her employment with Regina.
Well, counsel, the trial court in its entry said that the plaintiff has cited no evidence that created a genuine issue of material fact regarding whether or not they mailed that notice. Whether or not they mailed that notice.
Well, they provided no proof that they actually mailed it. There were disputed facts as to whether it was mailed. As a matter of fact, the election form didn't even contain her address or name.
I think the response to that was the election form came with a letter on top.
It did. It was supposed to be enclosed with the letter. However, she testified she never got this letter. And they were unable to provide any evidence that it actually was mailed out.
Well,
they say it was, but there's no evidence that it was.
Assuming that they needed to send this notice under the law, is whether or not she received it relevant to whether or not they mailed it?
Well, I mean, first of all, under the mini-COBRA statute, unlike federal ERISA and COBRA, what the statute says is that the employer must advise the employee at the time of termination that they have these continuation rights. So arguably, it's not even supposed to be mailed. So you could argue that it's something that they should have presented to her. personally, or at least verbally. And I think it's important, the testimony from the people that were in charge of providing these notices. You have Donna Spiegel, Senior Director HR for the diocese, who says she was unaware that Ohio law even required that continuation of health benefits, any such notice be sent. She believed that the diocese was exempt from any such requirement. You have Joyce Haynes, the Assistant Administrator for Regina, who says she has no knowledge whether Regina was required to follow COBRA or the mini COBRA statute, and she has nothing to do with that. She was unaware of any benefits continuation policy that was referenced in Regina's own handbook. So here you have testimony from those who would be responsible for administering continuation of benefits, or at least providing notice, stating they're not aware of that legal requirement, they don't do anything about it, and it evidences that they clearly didn't care about the Ohio mini COBRA statute. There was also an argument made that she had no damages. And there was testimony that she did in fact have damages. She went 8 months without any coverage whatsoever between January of 2018 and September of 2018, when she was able to get covered through a group plan through subsequent employment. She had out-of-pocket prescription medications that she provided proof that she had paid for without any insurance coverage. And she testified that during this period of absence of any other medical care besides prescriptions, that she decided to forego medical care during that period of time because she wasn't insured, and she did not feel she could afford bills out of pocket for medical care other than just paying for prescriptions.
Counsel, can you speak to her rights for an individual cause of action under, we're going to call it the mini COBRA statute?
I'm not aware of any authority that would say that she doesn't have a private cause of action under the mini COBRA statute. I know that argument was made relative to a different statute. It was, that was our last count. It wasn't the mini COBRA statute though. It was the unfair trade practices, that there was no private cause of action.
In terms of the arguments that were made in the brief?
Right. But relative to the mini COBRA statute, there's never been an argument made that she cannot enforce her rights under the mini COBRA statute. Just like people all the time enforce their rights under the federal COBRA statute. We've had many cases under federal COBRA where we've gone in and shown that the employer did not provide the notice of continuation of benefits, and that causes harm to the person. It's a very strict requirement. The only argument that they really have relative to the mini COBRA is the language in the statute. I'm sure it's going to come up with my opposing counsel. It says the employer shall notify the employee of the right to continuation at the time the employer notifies the employee of the termination of employment. And again, that's where I was stating, you have to look at the whole statute. If we give effect to the whole statute, the eligibility requirements strictly state it just can't be a voluntary termination, and you can't be discharged for gross misconduct. Otherwise, you are eligible. She meets all the eligibility requirements. And it would serve no laudable policy justification to exclude constructively discharged employees from being able to receive notice of their continuation of benefits. She didn't leave her employment, again, because she just didn't want to work there anymore. She left because the conditions were intolerable. We have a separate lawsuit dealing with the harassment and the abusive conditions that caused her constructive discharge. Now, the trial court based its entire opinion on the mini COBRA statute, and it really gave short shift, we believe, to all the other causes of action. We also have a contractual basis for our claims, and that would be through the handbook. Even though the handbook itself may not create an employment contract, it can define the terms and conditions of the employment relationship if both parties manifest an intention to be bound by them. Regina's handbook had a very detailed section discussing COBRA, not even mini COBRA. Regina basically represented out there that employees had COBRA rights, and that they would receive COBRA in the event of termination or resignation. The handbook provides that a written notice describing rights granted under COBRA will be provided when the employee becomes eligible under the diocese health insurance plan. And even today, even though it was pointed out, that was pointed out to Ms. Haynes and others during depositions, they haven't taken that out of their handbook. So Regina established a policy or practice of following COBRA, which was published in writing to employees in the employee handbook. So even if federal COBRA doesn't technically apply, arguably they're stopped from not providing any sort of COBRA benefits, either federal or under the state statute. And there's Sixth Circuit authority to the effect that an employer can be equitably stopped from arguing that it's not covered by COBRA statute. And that was Thomas v. Miller, Sixth Circuit opinion in 2007. It's in our brief. That's also a basis for our promissory estoppel claim. The fact that this representation was put out there, this promise in the employee handbook, there was consideration for the promise through Ms. Phillips' dutiful performance of her job duties, and the employer, Regina, should have been responsible for following through with that promise and giving her continuation benefits, or at least giving her the choice to choose continuation benefits after her employment. We also have a breach of fiduciary account. That as well, I'm not sure that the trial court really even discussed that one in any sort of substantive way. That's also completely independent of the COBRA statute. They are a fiduciary because they're an administrator of the group health plan. And there's a common law breach of fiduciary cause of action because of that. Ms. Haynes testified that the diocese was the administrator for the health plan and are experts in that. Therefore, she testified that she'd have no reason to dissect this COBRA thing because the diocese was in fact a fiduciary as a matter of law, which is our argument. Diocese was a fiduciary, and Regina was also a fiduciary to the extent that it controlled what was taken out of employee paychecks to pay for the premiums for the health care coverage.
Counsel, let me ask you, I know you think there's an issue of fact, material issue of fact in regard to whether or not notice was sent and received, but you also mentioned that the trial court had addressed certain counts. Do you agree or disagree that everything rises and falls on whether notice was sent and received?
I do.
So the trial court would not necessarily have to discuss all those if she felt the notice, if she felt there was an issue of fact as to whether notice was sent and received.
I suppose, although the trial court never really made that express, the trial court never said the breach of contract claim fails because we don't find that Regina breached any implied contract by not sending notice. They just ignored those claims. They just focused on the claim under 392338 and 175153, which are together considered the Ohio COBRA law, mini COBRA law.
And counsel, I need to let you know you're into that 3 minutes
Okay.
rebuttal time. You're at 2 minutes and 39 seconds.
I will reserve the rest of my time for rebuttal. Thank you.
Sure.
May it please the court, my name is Brian Lang and I represent the appellees Regina Health Center in the Catholic Diocese of Cleveland. The appellees would request that this court affirm the decision of the trial court granting summary judgment in this matter. I've heard here this morning, I just want to make sure that it's clear, a suggestion that the appellees did not believe that this individual had a right to continuation of coverage. Pursuant to the policy, they did have a right to continuation of coverage beyond what's even provided under the mini ERISA statute, which only provides for 12 months. Under the policy, you could actually get 18 months. The issue with the language of mini ERISA that comes into play here is the plaintiff has suggested that this notice should have been provided on the date of termination. There's no date of termination in this case. A note was left with the facility saying, I'm not coming back to work. This isn't a situation where the employer terminated the individual, provided them with a packet of documents at that time that might include a notice. That the plaintiff is the one that terminated the relationship. And I understand the argument is it's a constructive discharge, but it's impossible for the employer to provide a notice of right to continuation of coverage when they don't even know the person isn't working anymore. So what they did was they provided a notice after that date, as the appellant has suggested, about a week later. There has been testimony that that notice was provided. There is a document that is part of the record of this court that has a signature on it. The person that signed that document has testified that it would have gone out. There was extensive questioning regarding these notices during depositions, whether there has ever been an allegation in the past of these notices not being received. And the answer is no. This is how it's been handled for years and years and years. And nobody has alleged this until the appellant in this case. With that said, I want to first address damages, and I'll eventually address each specific claim, but if there aren't damages, all of the causes of action fail. So the plaintiff largely ignored damages below and in their initial merit brief, but they've suggested in their reply brief that the plaintiff suffered depression as a result of the claims in this action. But if the court reviews the record, reviews the testimony of the plaintiff specifically says at page 113 and 114 of her transcript, she was not depressed because she didn't have insurance coverage. She was depressed because of the events that led up to her constructive discharge, which, as the appellant has let you know today, are part of a separate case. So that there's a case that's been filed for constructive discharge. Depression certainly is an aspect of that case, as is the fact that she's no longer employed. But in this case, we're talking about the lack of insurance coverage for a period of actually 6 months, not 8 months, but that's beside the point. But the plaintiff is essentially claiming here that they had concerns because they did not have coverage for that period of 6 months. The plaintiff hasn't presented any expert testimony establishing any sort of injury because of that, or presented any sort of bills reflecting depression, medical records reflecting depression. I've heard prescriptions for depression here today. We haven't seen a single record reflecting $1 spent on prescriptions during that 6-month period of time. In fact, we haven't been presented with any evidence of any economic damages for that 6-month period of time. Under the plaintiff's theory of the case, the defense can produce documentary and testamentary evidence establishing that they sent the notice that they should have sent, and the mere testimony of the plaintiff that it was not received and they were concerned with not having insurance for a period of 6 months when they had no medical issues, nothing that happened during that period of time, which she admits she was healthy, wasn't having issues, that should somehow overcome summary judgment. The plaintiff has not established any actual damages, and a concern for not having insurance for a period of 6 months is not a recoverable damage under Ohio law. The defense has been unable to locate any case that would suggest that that's recoverable. The plaintiff certainly has not presented any such case to this court. The only cases the defense is aware of that kind of wade into those waters of concern are cases involving concern for developing cancer when someone has been exposed to toxic chemicals. And courts have actually varied as to whether that's compensable or not. Obviously, it depends on what jurisdiction you're in with that, but I don't see how we can equate somebody that has been exposed to a toxic chemical that has concerns for potentially developing cancer with someone that didn't have insurance for 6 months, didn't have any health issues during that period of time. They just don't equate. There's no legal grounds to support damages for a concern. And it's clear the plaintiff is grasping at straws, hoping this court will overturn summary judgment, and then intends to use the defense cost of a trial to try and extort some money from the defendants in a baseless action. Notably, plaintiff's counsel attempted to do the same thing with Brittany Frazee, who was a witness in this case, another employee of the defendant. Ms. Frazee was deposed in this action and has been presented by the plaintiff as another individual that didn't get the proper notice when she was terminated. Her testimony at her deposition was she didn't know if she got it or not. She certainly wasn't confident in that issue. She didn't know. But what's interesting is the night before that she was deposed in the case, she was contacted by the plaintiff in this case. And the plaintiff told Ms. Frazee, quote, "My lawyer is still asking where you went because you know you are sitting on free money," end quote. So plaintiff's counsel is going out trying to manufacture claims for people that allegedly didn't get this notice, despite the fact that, again, and we have testimony, we have the actual document, the document is actually signed, we have a course of business. But Ms. Frazee wisely didn't pursue any sort of action. The plaintiff has failed to present a single bill associated with medical care during the 6 months applicable to this case, let alone any kind of damages that rise above the $627 a month she would have had to pay in insurance premiums. And the plaintiff should be thanking us for her not getting this notice, because she would have been out over $3,500 in premiums. But again, the notice was sent. Plaintiff has also admitted, again, I mentioned this before, any alleged depression she had was related to her discharge, not the lack of insurance coverage.
Counsel, let me just ask you, with your summary judgment motion by Regina, what arguments did you raise that you were entitled to summary judgment?
We raised that the plaintiff did not have any damages in the, for any of the claims, and because of that, the summary judgment should be awarded. We also raised that with each specific aspect of the claim, the elements of the cause of action were not met, which I'm about to address with you.
So those are the two arguments?
Yes, those are the two main arguments. And on top of the fact that the notice was sent. I mean, the evidence in the case is that we complied with what we were supposed to do. With respect to the breach of contract claims, the plaintiff is attempting to premise these claims on an employee handbook, language in an employee handbook that refers to COBRA. We don't know the last time that employee handbook was revised or amended. With that said, we do know that it has a disclaimer at the beginning of the handbook that states that this is not a contract, it's provisory, and there's an extensive line of cases in Ohio that have been addressed in the briefs that with that disclaimer, an employee handbook does not create a contract. On top of that, the testimony of the plaintiff in this case is that she has never seen the handbook. So I guess my understanding is the argument is that there is a contract based on the employee handbook between two parties, the plaintiff being one of them, when the plaintiff has never read the employee handbook. I don't understand how there can be assent to terms of contract if the plaintiff has never actually seen the alleged contract. Beyond the breach of contract claim, promissory estoppel is based on the very same document. The allegation is that Regina promised to provide COBRA coverage in this employee handbook. Setting aside again the fact that there's a disclaimer in there, for promissory estoppel you have to have justifiable reliance. That topic was not addressed in the appellant's briefing, nor was it addressed here today, because there is no justifiable reliance. How can someone rely on something that they've never even seen before or been aware of? So the elements of a promissory estoppel claim are not met. Fiduciary duty claim. The appellant has failed to present any evidence that the diocese was a fiduciary. The evidence to date in the case is that the diocese was a plan sponsor. They would send out notices when your coverage terminated, but they're not handling money, determining where to invest money. They have ministerial tasks that they perform. So they do not meet the standard of a fiduciary. It's important to note herein that the defendant has presented documentary evidence, including a signed and dated notice and testimony from the individual signing the notice reflecting that it was sent. This, as the judges have pointed out here today, the second document, which does not have a date or a name on it, was enclosed in that with that letter. So the letter is signed, it's dated, it's sent to the right address. Plaintiff claims she never received it, but she also admits that her mother recovered her mail 3 days a week, and her mother would often throw out junk mail. If the plaintiff's claim is allowed to proceed herein, it will lead to fraudulent prosecution of these types of claims. All the plaintiff has done in this action is offer her own testimony that she did not receive a notice that was clearly sent. The plaintiff has failed to present any evidence of any economic damages related to the alleged failure to receive the notice. The plaintiff has even admitted that she did not suffer any emotional distress regarding not having insurance for 6 months, and that was related to the circumstances surrounding her discharge, which is a separate case. Rather, her entire basis for damages is premised on a concern that something could happen to her when she didn't have insurance. Plaintiff has failed to corroborate their claim in any meaningful way, and this action should not be allowed to proceed. Your Honors, it is clear that plaintiff has failed to present evidence to establish each element of the claims asserted in the complaint. Accordingly, appellees Regina Health Center and Catholic Diocese of Cleveland request that the court affirm the decision of the trial court. Thank you, Your Honors.
Thank you.
Thank you. First, I'd like to address the time of termination. Ms. Phillips personally hand-delivered her letter, her notice, that she was not coming back. That was hand-delivered, it was known. Matter of fact, the nursing supervisor who got it called others that same night to let them know that Ms. Regina was not coming back. I mean, not Ms. Regina, Ms. Phillips was not coming back. So the trial court doesn't even discuss how, even if that letter had been mailed out, which we don't think it was actually mailed, even if it had been, how would that be timely under the Ohio Mini-Cover statute? It has to be at the time. They have to provide notice at the time. And this is something where there's almost no case law in Ohio on the Ohio Mini-Cover statute. So there's very little guidance as to what constitutes notice. But the statute does say at the time the employer provides notice of termination. So that would lead one to believe that it needs to be something that's done right away, not something that's mailed out a week later, even if it could be argued that a proper notice was sent. And the trial court, again, not discuss the timeliness issue.
Counsel, let me ask you, with something the appellee raised, and that is, on summary judgment, I understand and, realize the case law says you can't be judging credibility and so forth. But at the same rate, if an employer presents evidence that they sent a notice and the employee just submits an affidavit that says, I didn't receive it, it sounds like every case could be made to go to trial just because when an employee says, I didn't receive something.
Well, and Regina also, though, couldn't provide any evidence or the diocese that it was actually sent. So there was no definitive testimony that, yes, we definitely sent this out. It was believed that they did based on the document, but nobody could confirm that.
So you're saying they didn't even meet their threshold burden?
Correct. I mean, other than presenting a copy of a letter that they say was sent to Ms. Phillips with a date on it and an address, there was no other proof that it actually was sent to her. Matter of fact, she never got such a notice until much later after the litigation had been filed. I believe they attempted another time, the second time, to send a notice.
Is that in the record?
It should be.
I'm going to need you to wrap up.
Okay, thank you. I'll rest and just ask that this court grant the appeal. Thank you so much.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal as well as posted on the Ohio Supreme Court website. Our next